Yes.
Item 1 for motion.
Your Lordship, may I seek your indulgence in making a mention on behalf of learned Miss Mary for part 2, item number 2. If this matter may be fixed on next Tuesday, that is the 22nd of October. She has already taken the consent of the other party, Your Lordship.
Item number 2, part 2,
Sorry, Your Lordship, part 2, item number 11.
11. What is the matter about? There's an IA out here.
Your Lordship,
Yes, it is seen that 11 has been adjourned. Okay. It was mentioned yesterday and it was adjourned yesterday.
Your Lordship, I think it is part 2, item number 10.
Are you sure? Because in item number 11 also, the additional AG, no, the government advocate is a party.
Your Lordship, it is part 2, item number 10.
You sure?
Yes, Your Lordship.
Consent has been taken from
Yes,
the
Your Lordship.
petitioners. Mention is made on behalf of Ms. Mary L. Kiante, learned additional PP for the state respondents for adjournment of the matter, and that the consent of the petitioners have also been taken. In view of the above, list in the next week.
Much obliged, Your Lordship.
May it please your lordship. My lord, this criminal petition is
Item number
filed.
1.
Yes, item number 1, my lord. This criminal petition is filed by me to challenge 2 orders, my lord. The first order is dated 22/5/2024. This is regarding corruption case, my lord, PC Act case. And I was first of all, at the time after filing of the original charge sheet and when the charge was framed, I was discharged by the Learned Trial Court. Nothing was found against me. And thereafter, trial was conducted and 20 witnesses, prosecution witnesses were already examined. And now it is at the stage of examination of the 2 accused persons against whom trial had been proceeded already. And thereafter, my lord, on the verge of finalization of the trial, the case IO had submitted 1 application for re-investigation and filing of supplementary charge sheet. Then that was allowed by the Learned Trial Court, and I'm challenging that order first. And thereafter, I was recalled after being discharged. I had been recalled, and I was asked to appear before the trial court for delivery of documents. And that order also I am challenging, my lord. That is the reason why I am filing this criminal petition. And the case IO's only submission made in the application is not the case IO. It was the SP, Superintendent of Police, SCB, who submitted the application for reinvestigation. And if we look at section 173, subsection 8, there can be no reinvestigation, only further investigation. But there is catena of judgments is there of the apex court, saying that, my lord, on the finality of the trial,
Further investigation
Yes.
was allowed.
there re-investigation was allowed and supplementary charge sheet was also submitted.
Okay, now in the subsequent charge sheet that was submitted,
Yes, nothing
prima
new.
facie case was found against him?
It was stated like that, but nothing new was found, my lord. Nothing new, because it was exactly same as the original charge sheet, and I can show to your lordship also.
Anyway, we'll issue notice
My lord.
first. Let's see, then we can have a proper
My lord.
look into the case.
And in the meantime, my lord, I am praying for stay of that particular proceeding which is drawn against me, because yesterday it was fixed for opening of the case, and hearing was done to some extent. And thereafter, now we are waiting for the next court date. It is not yet fixed because order could not come out yesterday itself. So the 2 accused persons, it may be proceeded, my lord. But only in respect of my
Against
case.
the
Yes.
instant person, isn't
Yes,
it?
it may be state, the
Now,
proceeding.
for against the other two persons,
313 examination.
it's 313, so
It
that
may
can
be-
continue.
Yes, that can continue.
Heard Mr. Bilal Ramega, learned counsel for the petitioner, who has filed the instant petition under section 528 of the BNSS, 2023, for quashing and setting aside the impugned order dated 22/05/2024, passed by the learned special judge, Prevention of Corruption Act, 1988, Mizoram, Aizawl in CMA number 13/2024, which allowed the prayer for reinvestigation and submission of supplementary charge sheet against the petitioner and also against the order dated 05/07/2024, passed in SR within brackets PCA number 4A of 2023, which is an order recalling the petitioner for delivery of documents inasmuch as he was arraigned as the accused after the submission of the said supplementary charge sheet. The learned counsel for the petitioner further submitted that the case at present is at the stage of opening of the case, wherein the learned,
In respect of the present petitioner, ma'am.
yes, wherein the learned opening of the case in respect of the present petitioner. What happened? Wherein was it heard?
Yes, yesterday it was heard.
Wherein the matter was heard yesterday. And order of the learned trial court is still awaited for fixing the next date for appearance. The learned counsel thus prayed that the proceedings against the instant petitioner may be stayed till the disposal of the instant petition. Here, on hearing the submissions made by the learned counsel for the petitioner, notice is to be issued to the state respondents. Yes, you're going to accept notice, Ms.
Yes, my lord.
Vani Sangi, learned additional PP accepts notice on behalf of the state respondent. No need to issue any formal notice. Meanwhile, considering the nature of the submission made by the learned counsel for the petitioner, this court find it fit to stay the further proceedings against the instant petitioner in SR within brackets PCA number 4A of 2023 till the next returnable date. List after 2 weeks. When will you be ready? List after 2 weeks.
Yes, sir.
Much obliged.
Obliged.
For admission, item 2.
My lord, in this case, the new deputy commissioner of Siha district was recently implemented as respondent number 10. And I have been informed that Miss Mary has received instruction to appear on behalf of this.
Where's
respondent
Miss
number
Mary?
10.
Your Lordship, I'm on her behalf today, Your Lordship, and she's facing personal difficulties. That is why she's not able to attend today, Your Lordship.
Okay, Mr. Victor L. Ralte, learned counsel for the petitioner, is present, while mention is made that Miss Mary L. Kyangte, learned counsel, is likely to represent respondent number 10. However, since Ms. Mary L. Kyangte, Learned Counsel, is absent today, list in the next week.
Much obliged, Your Lordship.
Item 3.
Lordship, Mr. Roshan Subedi, counsel for the appellant, requested me to make a mention on his behalf that I have checked the
What?
I have checked the registries note, my lord. Respondents 3, 4, and 5. Notice is still awaited, my lord. AD card has not yet returned. So it may further be awaited,
Yes.
my lord. At least for 2 weeks.
But you're not here.
I am not here, my lord. I make a mention on behalf of, as per his request, Mr. Roshan Subedi, my lord. And today he's having personal difficulties.
Mr. B. Lalramega, Learned Counsel, makes mention on behalf of Mr. Roshan Subedi, Learned Counsel for the appellant, that the Learned Counsel for the appellant is not able to appear due to some personal difficulties. Yes.
Your Lordship, I'm appearing on behalf of Mr. Johnny L. Tolsong, who is for the respondent number 1.
Mr. Your good name?
Joel Patel.
Joel Pujao appears on behalf of his senior, Mr. Johnny L. Tauchong, Learned Counsel for respondent number 1. On perusal of the office note, it is seen that notice upon respondent's number, return of notice, okay, upon respondent's number 3 to 5 is still awaited. In view of the above, we may await for return of AD card from respondent's number 3 to 8, list after 3 weeks.
Obliged.
Item 4.
Yes. This is a review petition.
Yes, my lord. I believe my learned friend had wait for some time for filing objection in the IA.
Let him submit. You will submit for him. Yes. Are you going to submit
Yes,
any
yes, my lord. We will be submitting the affidavit on Monday
of what?
of the
Written
IA.
objection?
Yes, my lord.
Not the IA, the written objection.
written objection.
Isn't it? Yes. Mr. Nalfakoma, Learned Counsel for the applicant, is present along with Mr.
J.H. Rikela Rothfella.
J.H. Rikir, is it?
Yes, madam.
Fella, Learned Counsel for the opposite party. The Learned Counsel for the opposite party has prayed for time to file his written objection. In view of the above list, after 2 weeks.
Deeply obliged.
Obliged, my lord.
Item 5.
Service of notice is still awaited. If I may be granted another time, another week's time, my lord. In the meantime, I think we'll have to call the LCR also.
You know, one thing I've noticed is this criminal revision petition.
Yes.
There's an appeal, but if you read the nature of the petition that is submitted, it looks like an appeal for setting aside the order, isn't it?
Actually, yes, my lord, the conviction term is 5 years. So, if we are to
So you-
challenge the impugn order, then we have to come as a criminal revision, my lord. So, we prefer the present.
So it is only against the term of sentence, is it?
Yes,
Not
yes.
against the conviction order.
It's against the,
You're not filing the revision against the conviction, but only against the term of the sentence, is it? If it
No,
is
my lord.
against the conviction, then you appeal.
5 years.
because, my lord, the situation is that in order to challenge the conviction and the conviction and the order of this sentence, along with the conviction and the sentence, then
So
conviction
you
term is
are
to be
not
more than
challenging the
7.
conviction, you are challenging the terms of sentence, is it?
in both the
So
sentence
if
and the
you are
conviction.
praying for setting aside of the conviction, then it is obviously an appeal. You're appealing against the order.
Because, my lord, the conviction term is only 5 years. So it has to be more than 7 years if I am to prefer an appeal against this impugn order, as per the relevant provision of the CRPC, my lord. So, as the term is only 5 years, that
Only
is less
5
than,
years.
less than 7 years, yes, my lord. So I have to come as a revision, my lord. But I am challenging the conviction and term, the sentence order also, which I also enclosed in the revision petition, my lord.
Grounds for revision.
My lord, yes. All those
Conviction
grounds.
is under section?
The conviction is under section 10, but the charge is under section 6 of POCSO. The conviction was made under section 10 of POCSO Act.
Okay. Anyways, the stage is now at the stage of issuing notice. Is
Madam.
it? To respondent number 2.
Yes, my lord. The informant.
Heard Mr. F. Liana, learned counsel for the petitioner, along with Mrs. Linda L. Fumble, learned PP for the state respondent number 1. The learned PP submits that notice upon respondent number 2 is not complete till date and has prayed for further time. In view of the above, list after 2 weeks.
2 weeks, madam.
Meanwhile, LCR is to be called for. Yes.
For order, item 6.
My lord, today, this IA number 32 of 2024. There are 2 IAs. The other one is for stay. And today,
What is the
IA
idea?
32, 2024, condonation of delay.
Oh,
Application
so
for
we have
condonation of
to
delay.
dispose of the condonation of delay first,
Yes, my
isn't
lord.
it? Yes,
fact,
are we
this-
ready today?
Yes, my lord. In fact, your lordship has already had this matter at length about a month back.
About, what
About a
was it
month back.
about? About a month back.
Yes, my lord. And as permitted by this court to file additional affidavit in support of the grounds taken by the applicants, I have already submitted my additional affidavit. The main grounds of the delay reasons is that, my lord,
How many days condonation? For how many days have you prayed for? The condonation is for
272 days, my lord.
272 days,
Yes, my lord.
almost 1 year.
Yes, my lord. The impugned judgment is from Lunglei district, and the main reason is that they have, the applicants were being referred by one council to another again and again. And I'm the third council who have ultimately taken up the case and filed this case before this honorable court.
Okay, when was the judgment and order passed?
The impugned judgment and order was passed on 24/6/2022. 24/6/2022.
And when did the present applicant approach the first council?
The first council, after the impugned judgment was issued, they have approached immediately to Lunglei. And then
When? So I'm just trying to find out
15
whether it's the fault
yes, my
of
lord.
the applicants or the councils.
councils, in fact, my lord, on the
So-
part of the applicants, they have,
So
Make-
you addressed my query.
yes, my lord.
The judgment and order was on 24/6/2022.
Yes, my
So
lord.
when did he take the first steps on?
On 16/7/2022, the applicant number one, there are 2 applicants. The applicant number 1 had met his counsel at Lunglei on 16/7.
Okay, within the limitation period?
Yes, my lord.
Then what happened?
And after going through the brief and prepare for the appeal, the suit, the jurisdiction pecuniary, it has to be before the High Court. So he had advised them to approach the different lawyer from Aizawl.
Okay, oh.
And
So when did he approach? So did he approach the High Court or no?
Thereafter, my lord, this regarding the advice for approaching defense lawyer was given to the applicant number 1 on 30/8/2022. 30/8/2022. And thereafter, my lord, the applicant number 1, after coming back from Lunglei, he had approached a new lawyer on 5/9/2022.
He approached a new counsel, is it?
Yes, my lord, new counsel. Before me.
Oh, okay, that's you.
Before me, my lord. This is the second counsel. I'm the
Okay.
third and last.
Okay, you're the third.
Yes, ma'am.
Okay, new counsel,
Yes, my lord. And the said council, whom they approached on 5/9/2022, is asking for all the relevant documents, and the same was, after procuring the same from Lunglei, it was furnished to the said lawyer. And after the said lawyer examining the brief, he informed the applicants that since he is mainly practicing the district court, he had advised them to approach a new lawyer who practice in the high court. And in between these two applicants, they have some indifference in choosing whom to engage the lawyers. And I was finally engaged on, they approached me on 18/1/2023. Before that, my lord, on 14/11 also they have met another lawyer, and they have also applied for certified copy of the impugned judgment order, but due to indifference between the applicants, their choice of lawyer, I was ultimately approached on 18/1/2023. And after examining the brief and obtaining all the necessary documents, I was engaged and filed this appeal
When was it filed?
on 22/6/2023. I was given complete instruction financially and by way of documents on 6/3/2023. 6/3/2023. And in the additional affidavit which I have filed as permitted by this court, I have enclosed the affidavit sworn by the previous lawyers, the sequence of how they have taken up the brief and advised the applicants to approach different lawyers.
So what are the documents? Okay, on a non-judicial stamp paper.
Yes, my lord. Annexure 1, page number 7, 8. This is in respect of affidavit which was made by one of the hotel manager at Guwahati, stating that the applicant number 1, while pronouncing the judgment, was in Guwahati at his hotel. And on page number 9, annexure number 2, my lord, this is Sri V. Lal Mohanzola. He is the lawyer from Lunglei Court. First lawyer
First
from Lunglei
counsel.
Court.
Oh,
Yes, my lord.
okay.
And on page number 11, my lord, Mr. C. Vanlalmal Soma, whom they have approached after coming back from Lunglei.
So this is the first, second. In between, for a short time, there was also a third counsel.
Yes, my lord.
Who had asked for certified true copy.
Yes, my lord.
Is it?
Yes, my lord. And if I may take a lordship to only 2-3 pages from the main appeal, my lord. The suit pertains to money suit.
Yes.
The applicants were the defendants in the trial court. The present appellants were the defendants in the trial
Dependent.
court.
Yeah.
And we are rendering contract work If I may take a lordship to page number 3.
3 of the appeal.
Yes, my lord. From page number 2, my lord, for better understanding of the parties, the
Yes.
role of the parties. This hearing, Manisud number 3 of 2017, I have read as it is in Manisud. These plaintiffs were the subcontract supervisors of my work. I have rendered contract works from these defendant number 1 and 2, J.A. Brothers. J.A. Brothers. The defendant number 3, EPIL had allotted contract works to J.A. Brothers. And I was we are the subcontractor of J.A. Brothers.
So you're defendant number 4?
4 and
is
5.
it? 4 and 5. So you're saying in this case, the person who is responsible to pay the money is defendants number 1, 2, 3, not 4 and 5, is it?
Yes, my lord.
Is that your appeal, grounds for appeal?
Not only that, my lord, the plaintiffs in the trial court were the supervisors. I am the subcontractor. I was allotted the contract work by the defendant 1 and 2, J.A. Brothers. And now there is premature termination of the contract work. And before that, the applicants and the private defendants herein, the respondents herein have made an agreement, which is at page number 43, my lord.
So was this considered by the trial court? This
No, my lord.
agreement
No,
not
my
placed before the trial court?
It was placed before the trial court, but they were
So
claiming
your grounds of appeal is that this has not been considered.
the materials in its entirety is not considered properly, my
Okay.
lord. Now they're claiming rupees 45 lakhs plus. But the J.A. Brothers, from whom I received the bills, have stated that they have paid me only about rupees 13 lakhs. Without any evidence, the suit was decreed in favor of the plaintiffs and against the present appellants.
So your prayer in the appeal is what for? What is
To
your
set
prayer?
aside the impugned judgment
And?
order.
And what? Remand the matter back
That is up to your
to
lordship, my lord.
consider the evidence, is it? Anything? Nothing? Okay, fine.
And so far as the delay is concerned, my lord, the applicants herein have acted diligently from their end.
See, because basically in the end, we have to see how justice is to be rendered to both the parties, giving them the equal opportunity,
Yes,
isn't
my
it?
lord.
Anyways, that is at the later stage. Now, in the limitation. Yes, anything else to submit?
Yes, my lord.
So finally, you filed the appeal on 22/6/2023.
Yes, my lord.
Then, any authorities to rely on?
Yes, my
Or,
lord. State of Bihar versus Rameshwar Prasad Singh, 2000, volume 9 SCC, page 94. Para 11. In this case, the period of delay is 679 days. And the Honorable Apex Court had laid down the principles. Para 11, have you got it, my lord?
yes.
Power to condone the delay in approaching the court has been conferred upon the courts to enable them to do substantial justice to parties by disposing of the matters on merits. I'll skip few lines, then on the last sentence, it was further observed that a liberal approach is adopted on principle as it is realized that ordinarily a litigant does not stand to benefit by lodging an appeal late. Refusing to condone delay can result in a meritorious matter being thrown out at every threshold and cause of justice being defeated. As against this, when delay is condoned, the highest that can happen is that a cause will be decided on merits after hearing the parties. Every day's delay must be explained. Does not mean that a pedantic approach should be made. Why not every hour's delay, every second's delay? The doctrine must be applied in a rational, common sense, pragmatic manner. When substantial justice and technical considerations are pitted against each other, cause of substantial justice deserves to be preferred for the other side, cannot claim to have vested right in injustice being done because of an undeliberate delay. There is no presumption that delay is occasioned deliberately or on account of culpable negligence or on account of malafide. A litigant does not stand to benefit by resorting to delay. In fact, he runs a serious risk. It must be grasped that judiciary is respected not on account of its power to legalize injustice on technical grounds, but because it is capable of removing injustice and is expected to do so. And para 12, my lord, from para 12, after citing this judgment, my lord, it starts with, it is notorious and common knowledge that delay in more than 60%, have you got it, my lord?
Yes.
More than 60% of the case filed in this court, be it by private party or the state, are barred by limitation, and this court generally adopts liberal approach in condonation of delay in finding somewhat sufficient cause to decide the appeal on merits. It is equally common knowledge that litigants, including the state, are accorded the same treatment and the law is administered in an even-handed manner. When the state is an applicant praying for condonation of delay, it is common knowledge that on account of impersonal machinery and the inherited bureaucratic methodology imbued with the note-making, file pushing and passing on the buck ethos, delay on the part of the state is less difficult to understand, though more difficult to approach, but the state represents collective cause of the community. It is axiomatic that decisions are taken by officers proverbially at slow pace and encumbered process of pushing. I'll skip a few lines, my lord, then coming to after 5-6 lines, my lord. The courts should decide the matters on merits unless the case is hopelessly without merit. And besides this, my lord, if I may be allowed to place one more citation, Rafik versus Munsilal, reported on 1981, volume 2, SCC 788. 1981, volume 2, SCC 788. In this case, is on the grounds of default of the lawyer, my lord. It's a short, it's only 3 paragraphs, if I may read. We have heard Mr. Learned Counsel for the appellant and so Learned Counsel for the respondent. The High Court disposed of the appeal preferred by the present appellant in the absence of the Learned Counsel for the appellant. When the appellant became aware of the fact that this appeal had disposed of in the absence of his advocate, although the facts position are not similar, my lord, he moved an application in the High Court to recall the order dismissing his appeal and permit him to participate in the hearing of the appeal. This application was rejected by the High Court on the ground that though the application was prepared and drafted and an affidavit was sworn on so-and-so, the same was not presented to court till so-and-so, and that there is no satisfactory explanation for this slackness on the part of the learned advocate who was requested to file the application. The disturbing feature of the case is that under our present adversary legal system, where the parties generally appear through their advocates, the obligation of the parties is to select his advocate, brief him, pay the fees demanded by him, and then trust the learned advocate to do the rest of the things. The party may be a villager or may belong to a rural area and may have no knowledge of the court's procedure. After engaging a lawyer, the party remains supremely confident that the lawyer will look after his interests. At the time of hearing of the appeal, the personal appearance of the party is not only not required but hardly useful. Therefore, the party, having done everything in his power to effectively participate in the proceedings, can rest assured that he has neither to go to the High Court to inquire as to what is happening in the High Court with regard to his appeal, nor is he to act as a watchdog of the advocate, and that the latter appears in the matter when it is listed. It is no part of his job. Mr. So-and-so stated that a practice has grown up in the High Court of Allahabad amongst the lawyers that they remain absent when they do not like particular bands. Maybe he is better informed on this matter. Ignorance in this behalf is our bliss. Even if we do not put our seal of imprimatur on the alleged practice by the dismissing this matter, which may discourage such a tendency, would it not bring justice delivery system into disrepute? What is the fault of the party who, having done everything in his power and expected of him, would suffer because of the default of his advocate? If we reject this appeal, as Mr. So-and-so invited us to do, the only one who would suffer would not be the lawyer who did not appear, but the party whose interest he represented. The problem that agitates us is whether it is proper that the party should suffer for the inaction, deliberate omission, or misdemeanor of his agent. The answer obviously is in the negative. may be that the learned advocate absented himself deliberately or
So
intentionally.
the situation here, facts are slightly different. It's in
Slightly
the
different, my
absence.
lord,
It's not so much for condonation of delays,
yes,
isn't
my
it?
lord, but so far as the action of the applicants are concerned, they have acted diligently to their best since they came to aware of the impugned judgment. And now after approaching the lawyer, they are supremely confident that they will take up the case immediately. But due to some reasons I have stated already, my lord, the early counsels cannot take up the matter, and ultimately after they approach me, I have immediately filed this without any further delay. So on merits, my lord, if my application is not condoned, such illegality as I have stated earlier, it will be allowed to perpetuated, and serious injustice will be done. So, my lord, my humble submission is that the delay of 272 days can be condoned, and the appeal may be heard on merits. And
Yes.
I may be allowed to make reply subject to the submissions of my learned friends. I'm obliged.
Your Lordship, and for the respondent number 1 and 2.
Pardon?
1 and 2. Respondent 1 and 2.
Yes.
Yes.
1 and 2. How many respondents are there? 4.
5.
5 of them. The other respondents? Okay, the other respondents are also represented? All of them are represented, is it?
Yes, Your Lordship.
Okay, fine.
Yes, firstly, Your Lordship, regarding the applicant's contention that he was staying at Guwahati. In this regard, there is no actual record that, like hotel records or other records that he was staying, apart from the affidavit which was allegedly signed by one Mr. Hari Krishna Das. For all intents and purposes, we do not know his actual position, or whether he's actually holding the post of whatever he's claiming to be holding. So in this regard, we are saying that there is no proof of his travels, no proof of his lodging, because a hotel would usually give out some receipt or something to prove that the applicant was actually staying at Guwahati during the time from 25 to 6 to 12/7. Moreover, Your Lordship, in the original CMA condemnation application, it has been stated that he proceeded back towards Aizawl. When he came back to Aizawl, he immediately proceeded towards Lunglei on 15/7. But in the additional affidavit, his stay in Guwahati has been accounted for only till the 12th of July. So he went back to Aizawl, and 3 days we do not know his whereabouts, and he went back to Lunglei on 15/7. Furthermore, the additional affidavit says he became aware of the outcome of the case the judgment was pronounced on 24/6. He became aware of the judgment on 27/6. So during this time, he could have come back to Aizawl or Lunglei or wherever was necessary, and he could have pursued the case. But he continued to stay in Guwahati till the 12th of July for reasons which have not been specified in the condemnation application. He could have given priority to the case and could have pursued the appeal immediately after coming to the knowledge on 27/6. Secondly, Your Lordship, the submission of the applicant was that the previous counsel had been contacted to prepare an appeal on 18/7/2028. So after that, on 30/8/2022, he was informed that the matter had to be brought before the High Court due to pecuniary jurisdiction. Objection was raised in this regard that the applicant did not make any inquiry for 44 days between 18/7 and 30/8 with his counsel, and he had kept silent. So he had been silent for 44 days without making any inquiry as to whether how the appeal was progressing. So there was negligence on the part of the applicant as well. So after being informed on this is also supported by the affidavit in the additional affidavit, wherein the counsel had stated that he had only informed the matter to the applicant on 30/8/2022. So the applicant was quiet for 44 days until the matter was informed to him on 30/8. Now, Your Lordship, thereafter he approached a lawyer at Aizawl on 5/9/2022 and sought legal advice. He returned to Lunglei on 9/9 and collected the documents on 10/9. Now, Your Lordship, in this regard, the periods between 31 and 49, 31/8 and 31/8 to 49 and 6/9 to 8/9 have not been accounted for.
You have mentioned those in the original objection. I think you're reading from your original objection, is it?
Mostly, Your Lordship. But they had also filed the additional affidavit, so I'm improvising a little bit.
Okay, yes.
And regarding the missing documents which have been mentioned in subpara 6 and 7, the information was given to the applicant on 14/9, but the documents were purportedly sent only on 30/9/2022. So the period between 14/9 and 13/9 has not been explained as well. And there are no documents to show that the documents was actually sent on that date, 13/9/2022.
So 16 days.
Yes, Your Lordship.
See, now in para 6, 7 and 5, 6, 7, you have mentioned the dates which
Yes.
have not been explained.
Yes,
Is
Your
it?
Lordship.
19 days, then 44 days, and then 16 days, that is para 7.
Yes, Your Lordship.
Because you're reading very fast, so I'm trying to find out what, okay. Then
And then, Your Lordship,
para 8,
at para 8, the applicant was already aware that the High Court had to be approached. So he came to Aizawl and approached a lawyer. He could have sought a lawyer who was able to file a case before the High Court, but then he approached a lawyer who was not able to
he approached the wrong lawyer.
approach the long lawyer. So there was there was some negligence in that aspect as well. And in para 8 and 9, 9 and 10, there was no record of contact between the applicants. It has been alleged that both the applicant number 1 and 2 came into contact during this period, but there is no actual proof that the applicants had contacted each other, and that the applicant number 2 only became aware of the judgment at this belated stage. And with regard to para 11, 12 and 13, there is no record of contact with any lawyer between 10/10 to 14/10. And it has also been previously stated that all the documents had been obtained. All the necessary documents had been obtained. However, there is no reason. It is striking to see that the certified copies of the documents were only applied for on 21/11/2022.
It's
Moreover,
24/11 or 21/11?
21/11, Your Lordship. And the documents were sent to Aizawl were sent to the council on 25, were received by the applicant on 25/11, as per their application. Now, Your Lordship, even if we are to assume that the applicants had contacted lawyers, there are only 2 affidavits sworn by lawyers. So the period, the second lawyer had informed the applicants that he could not pursue the case on 10/10/2022. And they have stated that they met another lawyer on 14/11/2022. At page 6, para 10 of the application, they had at para 10, sub-para 10, they had stated that they met one lawyer on 14/11/2022, but there are no documents to support this contention that they had actually met this lawyer on 14/11/2022. So the period between 10/10/2022 till the time they met the present lawyer, which was alleged to be in January of 2023, has not been accounted for. Is my submission, Your Lordship.
Okay. Yes.
So my main contention is that there was also negligence on the part of the applicants, and that they could have pursued the case in a more diligent manner, and that such an extensive delay would not have been caused. Moreover, Your Lordship, as per the contention in the condemnation application, the present lawyers were met in the month of March. I think. He had given instruction to the present lawyers in the month of March 2023. However, Your Lordship, in this regard, I may also submit that there is no actual proof that they had actually met in the month of March, because the Vakalatnama would have been signed later before the filing of the case. So if there is no record that they had made any contact or that they had made any proper engagement in the month of March, then I believe that there is no proof to sustain their submission that they had met in the month of March and that the applicants had performed their due diligence in finding their appropriate lawyers. So my submission is that the application may be dismissed and that the applicants have not made sufficient grounds for condemnation of delay.
Yes.
Yes, Lordship, for respondent number 3 and 4.
Yes, Mr. Ram Murmu.
No, Mr. K. Thangram Song.
Pardon?
K. Thangram Song.
Okay, I get mixed up. Okay,
Yes,
Thangram San.
Yes, yes.
Oh. Okay, fine.
Lordship, so in this matter, my submission is that my learned friend already mentioned all the relevant dates and all. So, as per para.
Have you filed your written objection?
Yes, Lordship.
So you're referring to your written objection when
Yes,
you
yes,
say
yes.
para?
Yes,
Okay, let's see.
As per para 13
Wait,
of the
let
application.
me come to your written objection. This is Dusty. Yes. As per para?
No. As per para 13 of the application.
Okay, of the application.
Of the application, yes, Lordship. The present council were furnished all the documents on 23rd 1 2023. After that, they found out page number 15 of plain was missing, and again that the missing page was furnished on second.
Okay, this is sub para 13.
Yes,
okay.
para 13, yes. 2 to 23.
Okay, yes. So they found out the papers
Page,
missing.
yeah, page number 15 of plain was missing, and that was furnished to the council on 6/2 2023.
On 6/2/2023.
Oh, yes,
I
yes,
think.
6/2 2023. And here in Lordship, we found out that due to financial constraint, they give complete instruction only on 6/3 2023, which is after 47 days from the date of they were approached. So, in Lordship, in this para, I would like to submit is that if they have this kind of problem, so they can approach legal aid also.
Okay.
So, I think, Lordship, there is a mistake from the applicant side, and this honorable court may.
Okay, so you're saying that financial constraint
Yes,
is not
yes.
a proper excuse.
Yes, yes,
They have
yes.
the option.
Yes,
Okay,
Procedural.
got your point.
And there is no sufficient cause.
How many days was the delay for financial constraint? 42 days?
Yes, 47 days.
47 days. Okay. Yes, anything else?
And that's all, Lordship. No further submission.
Okay, heard Mr. Victor L. Ralte, learned counsel for the applicant, who has filed the instant application for the continuation of 272 days in filing an appeal against the judgment and order dated 24/06/2022, passed by the learned senior civil judge, Lunglei District in money suit number 3 of 2017. The learned counsel for the applicant submits that he was informed of the impugned judgment and order dated 24/06/2022 on 27/06/2022. However, the applicant number 2 could not be contacted at that stage, while the applicant number 1 was at Guwahati. The applicant number 1 came back to Aizawl and proceeded to Lunglei on 17/07/2022.
15/7.
Okay, it's 15/7/2022 to meet his counsel. He was advised by his counsel to file an appeal and as such the applicant number 1 returned to Aizawl to discuss the matter with the applicant number 2. It was then observed by his counsel that he would have to approach the Guwahati High Court due to the pecuniary jurisdiction on 30/08/2022. As such, the applicant number 1 approached a new lawyer on 05/09/2022, wherein he was asked to bring all the materials pertaining to the case. Stop. Okay. The applicant number 1 had therefore gone back to Lunglei to collect the briefs from his previous counsel. Stop. Thereafter, he had to again return to Aizawl on 12/09/2022 and met his new lawyer on 14/09/2022. His new lawyer, after examining the documents, informed him that he was incompetent. No, informed him that the records were incomplete and the applicant number 1 had to again request his first lawyer to send him the remaining documents through courier. On receiving the said documents on 30/09/2022, the said documents were furnished to his lawyer on 10/10/2022, so that an appeal could be filed before the High Court, Guwahati High Court, within brackets AB. Okay, eyes on bench. Thereafter, the applicant number 1 managed to contact the applicant number 2 and the applicants could finally decide on a common lawyer to take up their case only on 14/11/2022. This 14/11/2022, is it you or someone
No, my
else?
lord.
Someone
No,
else?
Some other council, my lord,
Okay,
who had applied the certified copy.
okay. On 14/11/2022, who advised them to apply for the certified copy of the impugned judgment and order. Full stop. However, due to certain differences between the applicants and also with the new lawyer, the applicants were advised to approach a different lawyer for the third time.
Please, ma'am.
For the third time. Accordingly, the applicants then approach the present council on 18/1. Is it correct? 18/1? On 18/1,
That was the first time
23.
they have approached.
The present lawyer then asked for the documents which could be finally furnished to him on 06/02/2023. Now comes the financial constraint, is it?
Yes, ma'am.
Meanwhile, due to financial constraint, the required formalities could not be completed, and finally, their present counsel was able to prepare the draft of the proposed appeal and file the appeal on 22/06/2023, which resulted in the delay of 272 days in filing the appeal against the impugned judgment and order dated 24/06/2022. Full stop. The learned counsel for the applicant further submits that the delay is not due to the fault of the applicants, but due to the constant change of the councils and due to the fact that the applicant number one was in Guwahati initially, full stop. In support of his submissions, the learned counsel for the applicant has also filed the additional affidavit, wherein affidavits to the effect that the previous counsels were engaged by the applicants have been enclosed. The learned counsel for the applicant has also relied on the decision of the apex court in those two cases. Okay, we get it registered, so and so. That full stop. And then after that, Mr. Jonathan Lilvin Tuanga, learned counsel for respondent number 1 and 2, has strongly objected to the condonation of delay of 272 days by submitting that the explanation given by the learned counsel for the applicant is insufficient and submits that there is no proof to show that the applicant number 1 was in Guwahati when the judgment and order, impugned judgment and order, okay, dated 24/06/2022 was passed, and he was informed of the judgment and order as early as on 27th, is it? 06/2022. He had delayed in approaching his first counsel only on 16/07/2022. Full stop. He further submits that there was negligence on the part of the applicant after he returned from Lunglei to Aizawl on 18/07/2022. And he should have been diligent enough to inquire from his previous counsel to prepare the appeal. He has not explained the period between 18/07/2022 to 30/08/2022. Full stop. The learned counsel further submits that there was a delay that the delay of 16 days, that is from 14/09/2022 to 30/09/2022, has not been satisfactorily explained which, according to the applicant number one, was the time taken by him to obtain the documents. The applicant number one was also negligent in taking time to approach a new lawyer. He further submits that the required documents were already obtained by the applicant and therefore the reason for obtaining the documents, delay in obtaining the documents and furnishing the same to their new lawyer has not been properly explained. The Learned Counsel has also pointed out that though it is said that the applicants number 1 and 2 were having differences in their choice of the new lawyer to be engaged, it is seen that they had taken as long as 21 days to resolve their differences. That is, from 25/11/2022 to 15/12/2022. I think documents have been explained, then the Learned Counsel also submits that the complete instructions was given to the council on 03/03/2023. However, the connected appeal was filed only on 22/06/2023, wherein there was a delay of over 3 months in filing the appeal, which has not been, wherein this delay has not been properly explained. This shows that there was negligence on the part of both the applicants as well as the present counsel in filing the connected appeal. The Learned Counsel further submits that from the steps taken by the applicants, it is shown that the applicants were negligent in taking steps for filing the appeal against the impugned judgment and order. Anything else? Mr. Jonathan?
What I had mentioned earlier, at page 6 of the application,
Page 6,
of
yes.
the condemnation application. After furnishing documents to his lawyer, he was informed at paras 8.
Of what? Your written
No,
objection
condemnation application.
in the condemnation application, yes.
Yes. At the first line, after furnishing such documents to his lawyer, he was informed by his lawyer on 10/10/2022. And after that, the applicants were silent about meeting a new lawyer, and they only met one lawyer again on 14/11/2022. Now, the other lawyers, they have somehow explained in the additional affidavit, but this lawyer has not been mentioned in the additional affidavit as well.
Okay.
So the period between 10/10/2022 until the time they met the present lawyer in the month of January has not been explained, October, November, December.
The learned counsel will put this somewhere in the middle. Okay, I'll improvise and make some improvements. The learned counsel further submits that he was informed by his, this would be the first or second lawyer on 10/10/2022 that the appeal was to be filed before the Guwahati High Court, within brackets, Aizawl bench. And after being informed, they had approached a lawyer only on 14/11/2022, whereby he was asked to obtain the certified copy of the judgment and order. This delay in approaching a lawyer, even after knowing that the matter had to be filed before the Guwahati High Court, has not been explained. So if we add that, anything else to be added?
As I said, Your Lordship, the other lawyers were supported had filed their affidavits stating that they had been approached by the applicants,
Okay.
but
There's no affidavit to support this claim that one, to support this claim. Okay, full stop, make it clear. Yes. Then Mr. K. Thang Rem Sang, learned counsel for respondent number 3 and 4, submits that while reiterating the submissions made by the learned counsel for respondent number 1 and 2, he submits that though the applicants have mentioned that they could not take necessary steps in filing the connected appeal immediately due to financial constraints, he submits that if they were facing financial constraints, they could have engaged learned counsels to represent them through legal aid counsel, which they did not do. This shows their negligence in taking steps for filing an appeal against the impugned judgment and order. Anything else to submit? Okay, this court, after considering the submissions made, I will give my full reason later, but the conclusion will be that this court allows the condonation of delay of 272 days, and accordingly the IA stands allowed and disposed of. My reasons I will give later.
My lord,
Now in the main,
yes.
now there's another IA. This is
This
stay.
another IA, my lord, due to the pendency of execution, which is being taken up promptly in the trial court, we have filed this IA for to stay the proceeding. And upon condoning the delay, and if your lordship is pleased to admit the appeal, this IA can also be disposed of and stay can be granted from the main appeal.
Okay, this matter was heard before and said that
till disposal of the condemnation application.
interim stay was granted till the disposal of the condonation application, isn't it?
Yes, my lord.
Anyways, let's look at the appeal. Yes, on the disposal of IA within bracket C 74/2023, wherein the court had allowed the condonation of the delay in filing the instant appeal against the judgment and order dated 24/06/2022. Notice be issued to the respondents. Then Mr. You're going to accept notice here, isn't it? I get confused with your names. Yes, Mr. Jonathan so-and-so accepts notice on behalf of respondent number
1 and 2.
1 and 2. Is it? While Mr. So-and-so accepts notice on behalf of respondents number 3 and 4. Requisite copies of the appeal, memo of appeal is to be duly furnished to the learned counsels for both the parties. Now, is LCR required to be called for?
It will be required, my lord. Before that, my lord, if I may, there is also respondent number 5. And
Okay.
while considering the IA of for delay, I have taken justice service upon the respondent number 5, and in the IA on condonation of delay on 22/2/2024, service upon the respondent number 5 was already
Is complete, but not appeared today. Anyways, meanwhile, notice be issued to respondent number 5 through registered post.
My lord,
Oh.
if I may, to
AD.
Dusty, my lord. to
Okay.
Dusty.
We'll do it both ways. Okay, through registered post with AD
Yes, my lord.
within 3 days, returnable by 3 weeks, as well as through Dusty service, wherein affidavit to the effect is to be duly submitted within 3 weeks. Now, this is concerning the RFA. Now, there is an IA.
My lord, before coming to the next IA, if the IA is going, I believe that it will be disposed of. And in the main appeal, my lord, stay may be granted. To
Now,
stay the appeal
no,
just
but in the IA, this IA of yours is for stay, isn't it? Stay till the disposal. Now, this IA itself has not been disposed of. Because in the IA, what was your prayer in the IA? Till the disposal of the condonation of delay application or till the... You see, because if you look at the order of in the IA, it appears that it is stayed till the disposal of the condonation of delay application. And then the main IA has not been disposed of because your prayer in the IA, what is your prayer portion in the IA for stay?
to stay the execution proceeding.
Till?
That's not specified. That is not specified.
Specified. And the IA itself has not been disposed of.
Yes, my lord. Only interim.
Initially, it was till the disposal, to state till the disposal of the condonation of delay application. Now, on the disposal of the condonation of delay application, will the IA previously filed by you still be surviving? I think it should survive instead.
Yes, my lord, it can be made absolute. Otherwise,
Because
you know.
the main issue had not been looked into as it is. See, because here Mr. Jonathan Lalrun-Tuanga had submitted that since the IA for condonation of delay has not been disposed, it may not be appropriate to stay the proceedings of the execution of the case at this stage. Okay, so then we had granted an interim stay
Yes. I understand, madam. This can be made absolute.
till the disposal of the IA, that is for condonation. So now, the next step will be to dispose of the IA, which is a prayer for stay of the execution of the, maybe till the disposal of the instant RFA, isn't it? So any submissions to make on this IA? Or no, will allow?
Yes, sir.
Now, in the IA, that is 74/2023.
Firstly, I have wrongly mentioned the IA number. The condonation is 74. This stay is 32.
Oh, yes, 32, yes. Now, in the IA 32/2024. On the disposal of IA 74/2023, now, why is it 2023? It should be 2020, it's 20, okay. On the disposal of IA, yes, 74/2023. Okay. Heard Mr. Victor L. Ralte, learned counsel for the applicant, along with Mr. Jonathan Lalrun-Tuanga, learned counsel for respondent number 1 and 2, and Mr. K. So-and-so, learned counsel for respondent number 3 and 4. Anything to submit in this 3 and 4? Nothing?
No.
This is an application filed under Order 41, Rule 5, read with Section 151 of the Court of Civil Procedure to stay the execution proceeding of execution case number 110/2022, pending before the Court of Civil Judge within brackets Senior Division close bracket -2 ISON till the disposal of the RFA number 22 of 2023, which is an appeal against the judgment and order of the learned civil judge within brackets Senior Division 2 in money suit number 3/2017. The learned counsels for the respondents submit that they will not be filing any objection to the instant IA. In view of the above, this court, considering the fact that the RFA 22/2023 filed against the impugned judgment and order dated
26.
where is it?
24/06/2022.
Oh, 24/06/2022. Find it fit to stay the proceedings of the execution case number so-and-so. Execution case number 110/2022. Till the disposal of RFA number 2022 of 2023. And thus stay the impugned order dated 07, is it? 12/2023, passed by the learned civil judge within brackets Senior Division 2. Accordingly, the IA 32/2024 stands allowed and disposed of.
Be obliged.
Yes, anything else?
Let's see.
Item 7.
I think the cost list is somewhere. Just see. Yes, item number 7.
Your Lordship, in this matter, there are two IAs,
Oh,
and I am here to file my objection.
My lord, if I'm not mistaken, this IA number 162, 2024, notice is yet to be issued.
this is additional evidence.
Yes, my lord. If I'm not mistaken, notice is yet to be issued.
You have made an application that you may be allowed to produce some additional evidence.
Yes, my lord.
And the other IA is what?
Stay
stay.
of
The impugned judgment.
So in the IA for stay, you're going to file a written objection,
Yes, Your
is it?
Lordship.
Okay. Heard Mr. Victor L. Ralte, learned counsel for the applicant, along with Mr. Jonathan so-and-so, learned counsel for the respondent. How many respondents?
I'm for 1, 3, 4, and 5.
Respondent number 1, 3, 4,
And Your
and 5.
Lordship, state respondents of 6 and 7.
And Ms. Lillian Louis, learned government advocate for the state respondents number 6 and 7. The learned counsels for the respondents have prayed for time to file their state. Are you going to file?
No, Your Lordship, not for the RFA, and for the IA, Your Lordship, I'm yet to receive.
The IA?
For the IA, Your Lordship, I'm yet to receive further instructions. Your
Okay. The learned counsels for the respondents have prayed for time to file their written objection. Unless after 2 weeks.
The interim
Now-
order may be continued.
Pardon?
There's an interim order.
No, this is in the IA for stay.
Yes, my lord.
Okay. Meanwhile, the interim order passed earlier shall continue till the next date of listing. Now, in the other IA, this is IA number 162/2024. Okay. Heard Mr. Victor L. Ralte, learned counsel for the applicant, who has filed the instant application under Order 41, Rule 27, read with Section 151 of the Code of Civil Procedure, 1908, for production of additional evidence. Notice be issued to the respondents. Then Mr. Jonathan Nalrin Tuanga accepts notice on behalf of respondent number 1 and 2.
No,
One
Your
to
Lordship, 1, 3, 4, and 5.
Okay, 1, 3, 4, and 5.
2 has passed away.
Two
One-
already expired. Yes.
Okay, 1, 3,
4,
4,
and
and 5. While Ms. Lillian Louis, learned government advocate, accepts notice on behalf of respondents number
6 and 7. Your
6
Lordship.
and 7. This is the matter after 2 weeks for the respondents to file their written objection, if any. Yes.
Leave them
Right.
alone.
For hearing, Part 2, Item 9.
Matters caller. None appeared for the parties. List after 2 weeks. Anything else?